I wouldn't want to do what you are bidding me to do. No, I wouldn't. I'm an innocent person. Now, if you ask me to do it and I implement it, the result will be this way or that way. Remember that all of us have different listening ears. What I hear from the same audio recording may be lost upon you. There are certain vital instances of assets there that may be lost on you or me, that a third or fourth or fifth person may find contained in the same document or audio. So different listening here. That is one. Number two, making inferences judicially. It's not as simple as we are making it sound. The judge was legally enjoined procedurally to return findings. She has seen the witnesses, she's observed their demeanor, and she's saying that as far as she's concerned, it couldn't have been the Attorney General. The larger general public is saying that reality is different from perception. Reality is different from perception. The larger general public is saying, or majority of us are saying that we heard it loud and clear. So if the trial judge says that he needed to make a finding in order, to return a verdict, and he made it, if any person is aggrieved, the relief lies in an appeal. Any of the party, be the prosecution or the defense, if they feel aggrieved, let them go on appeal.
Right.
That is why we have the appeal court. They can go further to the Supreme Court.
Right.
I am not thereby suggesting that the judge's conclusion was right, but I have witnessed the discussion and suggesting that if a judge can go right, the judge can go wrong.
In the manner in which the public commentary seems to project in an almost conclusive, manner that the Attorney General did wrong, is it not an invitation rather to the judge to make inferences and to make, interpretations and make conclusions from the conversation? Otherwise, what she has written down as what transpired on the tape is accurate. So people say, the Attorney General is heard saying, if you do it this way, my way, it will not pose any difficulty for you. People want the judge to make inferences from that, make conclusions out of that, and so on. Earlier, the communication from the Attorney General's department through the spokesperson was that in the meetings that were spoken about, the Attorney General simply told the witness to speak the truth. So if I ask you question A, just tell me the truth. The expectation on the judge, is it fair that she should be making inferences rather than telling us exactly what has been heard on the tape?
Thank you. Remember, in one of the interviews I granted to your station last week, I reminded the general public that the public of, the court of public opinion is overwhelmed. If you go there, you get lots and lots and lots of views. It's like watching Black Star. All of us become coach. Therefore, the judge sounded a caveat that please stop politicizing this issue. I am not going to be influenced by what you say in public. I am only going to perform my constitutional duty in accordance with the dictates of the Constitution.
All right.
The judge already sounded that. Now, where I find the judge's conclusion wrong is this. The same judge said Mr. Attorney General, you need to be strongly advised to recuse yourself. That alone ought to have formed the basis of deciding whether to admit or not to admit, or whether to rule on the fact that the Attorney General did not say that, or the Attorney General said that. She said that he should be strongly advised. What informed that advice? What informed? And she
had
didn't
said,
qualify the advice.
she has said, Ms. Ansa-Asare, Ms. Ansa-Asare, she had found,
moral turpitude.
yes, she had found and said, let me supply this briefly. She had found and said that where the Attorney General is heard asking the witness to go for a medical excuse, that for her, she said, is discomforting.
My brother, the words are mere words, but words are powerful. The court was not there to decide whether a conduct will result in discomfiture or not. The court had been called upon, the court had been invited to rule on the propriety of what the Attorney General had said. All of us have heard the tape several times. I am a lawyer, and I'm saying that I find everything wrong with the conduct of the Attorney General. It is not every lawyer who is going to toe my line, and it is not every judge who is going to rule that this is, this can only amount to a discomfiture, and therefore, discomfitures, do no harm to the law, or discomfitures do not make bad cases. As far as I'm concerned.
But her point is this. You are asking me ultimately to make an order that there has been a mistrial. And she says that in our body of laws, as far as the legislation or case law is concerned, there is no provision for the court to declare a mistrial on the basis of the alleged misconduct of a lawyer, either for the prosecution or the defense. And then she says, well, if you have issues, you can go to General Legal Counsel or somewhere else, but not here. Then she says that the Attorney General is talking to the witness in the manner he's heard talking to him outside of the court at a time when he is prosecuting him in the court. It's discomforting. So on the side of the law, I can't grant what you are saying, what you are asking me to grant. But in all, propriety, it appears that something hasn't been done right.
Well, the offense of witness tampering or obstruction of justice can be committed before or during or even after trial if it is intended to intimidate or influence the witness. It doesn't matter whether it was said in the courtroom or outside the courtroom, because outside the courtroom can be an extension of the courtroom. Here is an Attorney General leaving a courtroom, accepting an invitation to meet one of the accused persons in a private home. He shouldn't have done that. He did it. It is offense number one. Number two.
It doesn't matter. It doesn't matter. It doesn't matter that in that meeting, as they report, he was only saying, tell the truth.
But he lied.
Who lied?
He has lied. In telling Richard Jakpa how to go about excusing himself from the agenda itself constituted coaching. And we have remember that we have had an instance in this country where in the course of the trial of Nyantechi and Opon and Yeboah, who attempted to overthrow the NLC in 1967, in the course of the trial, one lawyer, one of the defense lawyers, S.K. Amufa has alleged to have coached Yeboah Oponya Ntechi, the two of them also. And he was convicted. We have several cases where lawyers have had to appear before the General Legal Council, where they have suffered the sanctions laid down by law.